Welcome to a fresh episode of Legal Wrangle, where we will track major judicial developments that have taken place in the last few weeks in the realm of international taxation. For this, we have selected three important cases. The first one discusses the taxability of profit accrued to an independent distributor engaged in sales promotion activity for a foreign entity. The second one discusses the withholding tax liability on arbitral award received by the foreign entity. And the third one discusses the taxability of reimbursement offered by overseas entity to Indian vendors as FTS. Our first case revolves around taxability and attribution of profit to an independent distributor engaged in sales promotion activities for a foreign entity.
Let's understand what exactly happened in this case. The SSE is a German entity which had sold fully built up cars and accessories to its AEs. For such purposes, the SSE had appointed Volkswagen Group Sales as the sole distributor of Audi brand cars in India. As per the AO, Volkswagen Group Sales was the exclusive distributor whose only source of income was from Audi business. He therefore held that SSE had business connection and PE in India in the form of Volkswagen Group Sales as per Article 5 Clause 1 and Article 5 Clause 5 of Indo-German DTAA.
Let's see what the tribunal finally decided. Sale of fully built up cars imported from overseas counterparts to dealers and distributors is independent activity to which no profit can be attributed as PE. Income arising from sales of good on principal to principal basis completed outside India cannot be taxed in India. Moving on to our second case, the High Court was approached to decide as to whether the arbitral sum awarded in furtherance of contractual dispute between the petitioner, that is Swiss company, and the respondent, that is Indian company, attract any withholding tax liability.
Let's understand what exactly happened in this case. Pursuant to arbitral award made in favor of the petitioner, the judgment debtor deposited the entire decretal amount along with interest up to the date of the deposit, part of which was released and part was withheld. The balance amount was kept back to ascertain the view of the IT department as to whether the decree holder could be called upon to pay withholding tax. When the decree holder approached the court for release of the balance sum along with the accrued interest, the revenue took the position that award attracted tax liability under Income Tax Act 1962 and India-Switzerland DTAA.
Let's see what the High Court finally decided. Compensation received by Swiss company in foreign arbitration for breach of contract from an Indian company is not taxable as windfall gain under Article 22 Clause 3 of Indian-Swiss Treaty. Sum received under arbitral award towards arbitration cost and legal cost by a foreign decree holder are not taxable income as FTS in the hand of such foreign entity. In respect of foreign arbitral award, assessment proceeding by the revenue are only tenable against the resident judgment debtor and not against the overseas entity having no PE in India. Now let's move to our last case, where reimbursement offered by overseas entity to their vendors for testing charges were deemed to accrue or arise in India as FTS.
Let's see what exactly happened in this case. The SSE is a proprietor engaged into trading business of engineering goods, which are mainly imported. During the relevant year, he imported customized engineered goods as per the specifications supplied by the Tata Motors, and for such purposes, he entered into an agreement with the vendors for developing, manufacturing and testing of customized products ordered by Tata Motors. In pursuance of the same, the vendor was to claim development and testing charges as reimbursements. The AO took the view that such reimbursements were deemed to accrue or arise in India and covered within the meaning of FTS.
Let's see what the tribunal had finally decided. Provisions of Section 9 Clause 1 Subclause 7 gets attracted if India is the situs for the service rendered. Payments made overseas cannot be categorized as FTS if no human intervention is demonstrated for receiving any technical services. With this, we wrap up this episode of Legal Wrangle And next time, we will bring some interesting cases from the world of domestic taxation. Thank you for watching. Goodbye.